For all you listening, we'll be getting started in just a few minutes. All right, everyone, we'll get started in just a minute. Hi, everyone. This is Carmen Disco. I am coming to you live from the UIA headquarters. We have an awesome show for you today. We are in conjunction with the National Hardware Show, bringing you some of the greatest workshops, some of the most information possible in the product and invention field. Today, we got an awesome guest with some really great information. We have a bunch of people, a lot of interest into this show. And we're going to introduce our guest. His name is Stephen Koziel, and I'm hoping I pronounced it right. I even asked him about it earlier. He's the Assistant Regional Director of the Silicon Valley Regional Office, United States Patent and Trademark Office, which serves the western region of the country. Mr. Koziel joined the USPTO in 2007 as a patent examiner and has managed teams of examiners in the computer graphics, digital imaging fields. Prior to joining the Silicon Valley Regional Office, Steve worked in the Rocky Mountain Regional Office in Denver, Colorado, where he led design implementation of various intellectual property outreach and education programs. He has also focused on the development of patent-specific programs within USPTO, including the Post-Grant Outcomes Program, American Invents Act, First Inventor to File Implementation, American Intellectual Property Law Association, Partnering in Patents, and patent operations cost and fee modeling. Jeez, unbelievable, all the stuff. Ms. Koziel received his Bachelor of Science degree in Electrical Engineering from Bradley University in Peoria, Illinois. Welcome, Steve. How you doing, my friend?
Hey, thank you, Carmen. Thank you to UIA and the National Hardware Show for welcoming the USPTO to this presentation today. Looking forward to a good conversation with the attendees here. So let's get started.
Yeah, great, Steve. I wanted to mention thank you so much for doing this presentation today, national holiday, and you're still able to come on and do this. So thank you so much.
Happy to do it, and welcome to all of those who are attending. Again, this is only going to be useful if you get your questions asked, so don't be shy. Use the chat feature, and I'm happy to have this as an interactive discussion with all of you this either this morning or afternoon, depending on where you are. So, looking forward to it.
Great, great. I have you all set up to share your screen if you would like, Steve, and begin whenever you're ready.
All right, let's get started. Okay, so hopefully you all can see my screen now. If you can just get a quick confirmation there.
We do. We see it.
All right, perfect. So I will go ahead and get started. I think we've got about an hour or so here together. I'll take about the first 50 minutes or so to go over some of the basics of intellectual property with a particular focus on patents, what they protect, what they don't, what you need to be aware of as you make the determination of whether or not you may need a patent or what type of intellectual property is right for you. And like I said, I'll leave the last 10 minutes for more of a Q&A. But I'll also pause periodically for some of your questions as well. And like I said, hopefully we can make this interactive. So don't hesitate to use the chat if you do have some questions, and I'm sure somebody will butt in if I'm not able to see them and ask them of me. Before we get started, though, I do want to say that these slides are approved for public consumption. So if anyone's asking if they could get a copy after the presentation, more than happy to send those your way. There's probably cover within the hour that we have together here today. So if I do go a little fast at times, don't worry. You can always refer back to some of the slides. So with that, I wanted to just take a brief moment to kind of introduce the Patent and Trademark Office, who we are, what we do, and why we're here talking to you guys today. So for those who aren't familiar, right, the Patent and Trademark Office is the federal agency that is responsible for examining and issuing patents in the United States, and for registering trademarks as well. With a reliable patent system, we believe that contributes to economic growth, and particularly it's our mission to create a reliable, predictable, and high quality intellectual property system within the United States, where rights owners, inventors, brand owners can really rely upon the enforceability of those rights and the predictability to start a business, to obtain funding, to grow your business, and to contribute to the economy through the backbone of strong, enforceable, and reliable intellectual property rights. So that's why we're here. That's why we're talking about IP and how it can contribute to your businesses today. And just by the numbers, right, we get at the United States Patent and Trademark Office a little bit north of 600,000 patent applications per year. That's been steadily increasing over the last decade or so, and roughly half of those issue as patents within the U.S. In any given year. And there's a few more statistics here. Trademarks, we get almost 500,000 trademark applications in any given year as well, and just a little bit north of half of those issue. So I find this graph interesting. It was about 2 summers ago, the summer of 2018, that we issued our 10 millionth patent in the United States. That's going all the way back to the very first numbered patent, over 160 plus years ago, to the present day, 10 million patents. And in a vacuum, that number really doesn't mean all that much. But one thing that stands out to me is just looking at the exponential growth of the issuance of patents, particularly over the last 20 years or so. And that really tells us why we're here today, why we're talking about intellectual property, and why we're going to be talking about patents in particular, as we see the importance to companies like yourselves, to your competitors, to everyone in the innovation space of intellectual property and of patents in particular. It took almost 80 years to go from the very first issued patent, numbered issued patent in the U.S. to patent number 1 million. And it took less than 3 years for the most recent 1 million U.S. patents to issue, to go from that 9 million to 10 million mark. So it's an incredibly active space, and it kind of shows why it's worth our attention and it's worth our time to talk about today. And to dig a little deeper, we talk about IP intensive industries and what they bring. Some numbers that stand out to me are just the value add of IP. Or there's a study, I believe it was about 4 years ago now, that looked at IP intensive industries across the US economy, right? Those industries that are really founded on or have a backbone of patents, trademarks, trade secrets, copyright, those who really owe their existence to a strong IP system. And they kind of contrasted that to those industries in the U.S. economy that are really outside of the of IP intensive industries. And some things stand out, right? That 46% higher pay, right? Employees who work in IP intensive industries take home 46% higher pay than those in non-IP intensive industries. And you can look at the total number of jobs that it supports, the contribution to US GDP. It really, IP punches above its weight class in the economic value that it brings to the U.S. and how that translates to better paying jobs, and really is supportive of the growth that we're seeing in the economy over the past decades. Um, so at a very high level, this is what we're talking about when we talk about intellectual property. And I know there's a lot going on in this slide, and I can probably spend just the next 50 minutes talking about this slide alone. But I do like to include this more for your reference than anything else, just so that you get a flavor of the different types of intellectual property, what they cover, what they don't, and what the scope of protection really is. And I'm not going to dwell on this, but this is probably the only time during the conversation that I'll mention things like copyright, trade secrets, and trademarks. So they're here for your reference if you do need to look into them a little bit further. But the majority of what I'm going to talk about today is the patent world. Specifically what we call utility patents, which are those patents that we think of as patents for invention. But I'll also briefly mention design patents as well. That's a lesser understood facet of intellectual property that covers the ornamental look and feel of a physical object. And I'll briefly mention plant patents as well, although I don't think they're of particular interest to this group here today. So looking at patents and looking specifically at U.S. patents, I think it'd be helpful for us to come to an understanding of what a patent actually covers, and more to the point, perhaps what it doesn't cover or doesn't protect. I think a lot of people have, their introduction to the patent system comes from, maybe watching Shark Tank, and the question is, is it patented? Is it patented? And that, I think, for the first time gets a lot of people interested in, oh yeah, what is a patent? What does it cover? What do I need to do to get a patent? So what we like to tell people is that a patent here in the U.S. is a property right. Much like the deed to your house conveys ownership of the land. A U.S. patent is a form of ownership of the particular invention that you have claimed in that patent. And a helpful way, I think, of understanding what a U.S. patent is that it's a right, not a monopoly, as many people say, but it's an exclusionary right, right? It's the right that grants you, as the owner of the invention through your U.S. patent, to exclude others exclude others from making, using, selling, offering for sale, or importing what you have claimed in your invention. And I emphasize that because, just obtaining a patent in and of itself um, does not mean that you have a monopoly on that particular product, or that you have the ability to generate, profits, or to corner the market on that particular product. It's simply the right to prevent others, right, to exclude others from, again, making or importing or selling what it is that you have covered in that patent. Another important aspect of that is I'd invite you to think about who enforces that right. Right, you have, okay, this slide is telling you have an exclusive right to make, use, blah blah blah. Who enforces that right? Right, is there a federal agency that looks at what you have patented and checks to see if somebody's selling it on Amazon, let's say, or somebody is attempting to manufacture it, or somebody's attempting to import it into the US? No, by and large, that's you as the right owner, as the owner of the patent. It's up to you, and particularly up to you and your attorney, to monitor the marketplace to see who is potentially infringing on your patented technology, who may be attempting to import some of your patented technology or sell it on Amazon, or any other type of e-commerce site. It really is down to your diligence, your vigilance in monitoring that which you have protected through your patents, and it's up to you to enforce that exclusive right. By taking a potential infringer to court in order to obtain an injunction to prevent them from selling or importing that which you have protected through your patent. So I do want to emphasize that as a note of caution, that just simply obtaining a patent is not the end of your journey in intellectual property, right? You have to then enforce that patent if you are successful. And let's face it, if you are successful, you will attract copycats, and people will try to copy that which makes you successful. And it's down to your and your team's diligence to monitor the marketplace in order to prevent others from trying to rip off your success through your patented inventions. Um, a few things worth talking about before we move on here is that a patent is a limited scope, a limited term of protection, right? You have 20 years from the date that you file your patent application to enforce that patent, right? That's part of the quid pro quo that's at the heart of the U.S. patent system, right? A patent application is essentially a how-to manual where you describe not only what your invention is, but how you came up with it in sufficient detail that anyone could pick it up, read it, and with a bit of skill, could be able to make that which you are claiming in your invention. So you're essentially telling the world how you came up with your invention, and how someone else could make it. And so in exchange for that, for that disclosure, you get a 20-year period of exclusivity that allows you to prevent others from making, using, or selling that invention. So that's the limited term, right? It's not like it's not like a trademark, which, as long as you're using it in commerce, can continue to exist. Right? Think about how long the Coca-Cola marks have been around, and they're still enforceable. There's no corresponding indefinite patent like that. It's a hard 20-year limit on U.S. patents. And I keep emphasizing US patents here because there really is no such thing as a worldwide patents. All patents, and in fact, all, broadly speaking, all intellectual property is territorial, right? A US patent is enforceable, right? That right to exclude that we talked about is enforceable only within the US. Right. So if, as you're thinking about your business, you're thinking about where you're going to be selling your product, or perhaps where you're going to be manufacturing your product, a US patent isn't going to protect you across the EU or across Southeast Asia or across China, or wherever your market or your manufacturing base may be. So something to consider if you decide that intellectual property, and a patent in particular, is going to be vital to prevent people from copying what your product is or what your inventive concept is, you need to think about, well, what percentage of my revenue am I getting from the US, right? If it's 90%, well, then maybe you just need protection in the US. But if you're drawing substantial revenue streams from the EU or Southeast Asia, China, Japan, wherever else, you really need to look at intellectual property protection in those countries as well, because again, your U.S. patent is only going to protect you in the U.S. And it's not going to. It can serve as the basis for your application in other countries, but it cannot protect you in other countries, right? So a key takeaway: all intellectual property is territorial. And if you're going to be manufacturing outside of the US, if you're going to be selling outside of the US, you need to think about obtaining the corresponding intellectual property in those countries as well. That may be important to you. So with that, I think I'll pause right here to see if there are any questions. Anything that I can address before moving on?
There, yeah, Steve. Actually, too, that kind of may include some of the things that you. There was one about if you see a product on Amazon that is blatantly going against your patent, and this came in. Um, who would you contact? Would it be Amazon, or would you go to an attorney or the USPTO? Who would be your first step if you can answer that?
Yeah, no, that's a great question, and it's one that we see that's particularly relevant these days. And it's something that Amazon, I think, has been, and not just to focus on Amazon, but it's e-commerce in general. Companies have been taking a bit more seriously in kind of policing some of these knockoffs. But to kind of take it back to the beginning, the U.S. Patent and Trademark Office is not an intellectual property enforcement body. Our role essentially ends upon the issuance of your US patent, right? We don't aid in the direct enforcement of that patent through an Amazon or any type of e-commerce or other platform where you may encounter counterfeits or people trying to knock off your product. So that would be that particular situation would be something that you, either on your own or through an attorney, would be interfacing with Amazon directly. And they have they have programs that I'm aware of, both for trademarks, if there's someone that's clearly copying your brand, and for patents, if there's someone that's clearly copying your patented invention, whereupon you can submit your patent number, submit the listing of the product that you believe is infringing your patents, and allow Amazon to take any corrective action that may be necessary there. I believe it's called Amazon's Neutral Patent Evaluation Program. I
Hmm.
don't quote me on that directly, but they do have a program that I'm aware of that that allows for for patented inventions and for products that may be ripping off a trademark or a brand name to be delisted on their platform. So that would be one of those situations where you work with the e-commerce platform directly to address those types of knockoffs.
Okay. Yeah, that sounds right, because it probably happens, as you said, probably happens more than we know about. And you can continue. We have a few other questions came in, but at the next pause, we'll hit you with some more.
Okay, great. I'll keep on going then. We talked a little bit about the what a patent covers. I'll mention briefly some of the other reasons that you should think about getting a patent. In addition to, again, being able to prevent others from kind of entering the marketplace that your particular invention is covering. There are branding aspects as well. I'm sure you've seen the commercials that advertise a particular product as patent pending or patented or covered by X number of patents. If that's valuable to you, if that's valuable to your target market, to be able to distinguish yourself on the basis of having patents to back up your product, right? That can be part of a marketing strategy. Right, so that's something you need to think about as well. It's also often used as the basis for attracting venture capital or Series A funding. A lot of, not all, but a lot of venture capital is hesitant to invest in a company that isn't supported by some type of intellectual property, right? If worst case scenario, if your company folds and is not able to be successful, right? And you have some patents, some trademarks, some intellectual property to your name, right? That makes it makes it easier for venture capital to kind of recoup their investment than a company that doesn't have the corresponding patents or intellectual property to their name. So again, it depends on the industry. It may not be as relevant as pertinent in some industries, but particularly those industries that that are involved in the sale of a physical product of something that can easily be copied, of something that can easily be kind of designed around. Those areas often are supported by having the patents, by having some type of intellectual property that makes you much more attractive to a potential venture capital investment. And licensing as well will be the last point I'll make here. A lot of really innovative companies think about ways to make particular products better, but they don't actually manufacture those improvements that they make to products, right? They license out the improvement, they license the patent for the improvement to a particular product or for a new design to a particular product, and somebody else does the manufacturing, right? And that's only possible by having a patent that you can, for the improvement to the invention, for the new design for the invention, that you can then license out and have somebody else manufacture or somebody else incorporate into their product, into their design. And in addition to that, patents can add value to your company, right? It's an asset. Think of every patent that you file, every patent that you obtain is another asset that adds value to your company because you can license it, right? Because you can use it as part of your pitch sheet going to to talk to venture capital, because it's something that that can survive changes in ownership in the company, or changes in the makeup of your management team, right? It's an asset in every sense that that your physical property is an asset, your real estate is an asset, any machinery, computers, 3D printers that you may have are assets. Think of patents and think of intellectual property as another asset, not quite as tangible as those, but it's something that can be sold, it's something that can be licensed, it's something that can be leveraged to obtain venture capital funding, right? It's an asset that contributes to the value of your overall company, in addition to being the primary tool that you have to prevent people from copying your idea. Um, so with that, I want to pivot a little bit away from the value, or what intellectual property can bring to your company, a little bit away from the why you should be thinking about patents and IP, and focusing a little bit here on the nuts and bolts of when you should think about filing. If you think you have an idea that's worthy of a patent, a product, an improvement that's worthy of a patent, or that you think should be protected by a patent, when do you actually need to file? And I think this is particularly relevant when you're in a position to start talking to potential investors, to people that might to people that might be selling your product, either in an online platform or a brick and mortar retailer. Um, when you're starting to talk about manufacturing, who's going to be manufacturing your product, what's the supply chain look like, who's going to need to know how the product works, or you're just shopping the idea around to see if there's a market for it. You're going to be talking to friends, to neighbors, to potential investors, and say, is this useful to you? Would you buy this? Um, you know, those types of conversations are potentially um, much more fraught than you might imagine, and I'll talk about why that is over the next two slides, because in the patent world, what you say to whom matters a great deal, particularly when you compare that to to when you actually file a patent application. And part of the reason for that is that the U.S., like much of the rest of the world, is what's known as a first inventor to file country. First inventor to file. Um, that means it doesn't matter when you came up with your invention, when you had that aha moment in the garage where everything finally came together, and the product was functioning. All that matters in the eyes of US law is when you actually filed your patent application. That is when the US recognizes you as the legal inventor of that idea that's contained within your patent application, right? So the aha moment, the moment of genius, when when you came up with the idea, when it finally worked, that has no legal relevance in the U.S. and in most countries across the world with functioning patent systems. It really all comes down to when you actually filed your application with the relevant patent office. So that's a very important thing to keep in mind, and you can kind of see why, because if you're working on something and you're talking with others, and kind of sharing that idea with others before you've filed, a patent application, you can see how that might put you at risk for, for perhaps somebody else taking it and going in a different direction and beating you to the patent office with a, with the corresponding filing. So that first inventor to file really kind of emphasizes the importance of being mindful about how much you say to whom and when you say it. And I'll go into a little bit more detail about what that looks like in the next few minutes. Let's see. And if there's one takeaway you have from this hour conversation today, I think it really should be this. It really should be that you need to be extremely mindful about what you say and to whom you say it prior to filing your patent application, because you can inadvertently void your rights to a patent in the US and to a patent in many other countries around the world for an inadvertent early disclosure of your invention. And by early disclosure, I mean publicly disclosing your invention prior to filing a patent application on it. So I want to spend a little bit of time going through some iterations, some examples of what that public disclosure could look like. So a public disclosure of your invention is anything from displaying that invention at a trade show, posting that invention on a blog or through an online video that really walks someone through the inventive nature of your product, of your invention. Any real offer for sale of your invention. Again, all of this assuming it comes prior to filing your patent application. And offer for sale is, as we understand it, includes crowdfunding campaigns as well, right? That's a popular way for people to raise revenue, especially for a beta or alpha product. Is these online Kickstarter or other crowdfunding campaigns, right? When you think about what that is, it's really an offer for sale of your product. And that offer for sale fits into this bucket of public disclosures of your invention. And here in the US, any of those public disclosures of your invention that I just mentioned, displaying it at a trade show, posting on the internet, an offer to sell your invention, any of those public disclosures of your invention basically start a 1-year clock running, where if you do not file a patent application on that invention within 1 year, then you are statutorily barred from ever being able to file a patent application or ever being able to obtain a patent on that invention which you publicly disclosed here in the US, right? So keep that in mind. Public disclosure is not a death sentence for your ability to get a patent, but it does start an extremely important 1-year clock, where if you don't file a patent application within 1 year of that public disclosure of your invention, you will be statutorily barred from being able to obtain a patent on that which you publicly disclosed. So in the US, I says that's 1 year. And that 1 year is actually fairly generous when you start to look at some of the public disclosure statutes around the rest of the world. In many countries across Europe, across Asia, there is no corresponding 1-year period between the time that you publicly disclose an invention and you can take it to the patent office. In many countries across the rest of the world, any public disclosure, whether it's in that country or in the US or in another country, any public disclosure prior to filing a patent application will automatically bar that invention that was publicly disclosed from being eligible for patent protection. So, just because you have a year in the US to file your application does not mean that you're going to be able to get corresponding coverage in the rest of the world where you may really need it. So the takeaway here is that public disclosure of your invention can be necessary, can be something that's very helpful because you need to drum up business at a trade show, because you need to you need to talk with a potential investor, you need to talk with a potential manufacturer, and you need to disclose the actual invention that they're going to be investing in, they're going to be manufacturing in, or that you want to link into a particular sales channel. There's tremendous value behind a lot of public disclosure, but do it wisely, right? In a perfect world, right, you would have your patent application already on file before any public disclosure of your invention. But if that's not possible for whatever reason, keep in the back of your mind that here in the US, from the instant you make that public disclosure, there's a 1-year clock that's ticking. And if you don't get your patent application filed here in the US within 1 year of that public disclosure, then you've essentially voided your rights to ever get patent protection on that invention in the future. So do keep that in mind as you're going through the hardware show, as you're thinking about who to disclose your invention to, or who you really need to disclose your invention to. It can impact your ability to subsequently protect your invention. And so with that, I think one of the last things I'll talk about here today is, so how do you actually get a patent? What's the process? What do you have to go through? Now that I've hopefully scared you maybe just a little bit, or got you thinking about the risks inherent in a public disclosure, and the value of having a patent application filed, at least prior to thinking about any kind of public disclosure. What does that process actually look like, and what does it take to get to that point where you can safely publicly disclose your invention, because you can say, I've got a patent application filed? So overall, this is just a high-level look at the process itself, and from invention to what we call a provisional patent application, all the way through granting of the patent. And I focus on the provisional patent application here, because that's the easiest and most cost-effective way to reach patent pending status, to be able to say that you've got a patent application on file here in the US. It is an optional process, but it's something that we recommend, or that we encourage companies to consider, particularly when cost is a factor, when they're looking for a low cost option to enter the patent system, when they're looking for kind of a quick way to keep costs low, but to be able to take full advantage of patent pending status, and to be able to have candid conversations, have that candid public disclosure of your invention. with the full knowledge that you have that patent on file, that patent application on file, and that you are protected. Um, a provisional patent application, for many filers, it'll be, I believe the filing fee is around $75 for what the patent office charges for a provisional patent application. And its filing requirements are greatly simplified relative to a full patent application. Basically, you need to submit documentation that clearly describes how someone of ordinary skill could make and use that which you have invented. It typically includes a narrative description. Many people find it helpful to take what's known as a problem solution approach to that narrative description, where you start with a particular problem that led you to that invention, describe kind of the state of the art as it is, describe how others might have attempted to solve that problem in the past and where they might have fallen short, and then use that as the basis for describing what what breakthrough that you had. What was it that you brought to that problem that hasn't been done before, or hasn't been done in quite the same way that you're doing it, and that, right, that description really is the basis of your patent application. As you describe in sufficient detail, again, enough detail so that somebody else could pick up that description and figure out what you did and figure out how they could make what you did. That when it at the end of the day, that is your patent application. It almost always will require some form of drawings, whether it's just a flow chart of what your of how to put together the product that you have, or it's actual drawing showing the individual components, how they connect, what they might be made of. But it's quite rare to have an application, a patent application anyway, that doesn't benefit from having drawings with it. So that's it. That's what it takes to really get to that patent pending status, right? That narrative description of the invention, supplemented by drawings, with a filing fee, and just a few other forms that identify who the inventor is. Any address that you may want your correspondence sent to, and the like, and that's it. That's how you get to patent pending status through the provisional application route. So I'll pause here again to see if there have been any other questions that have come through the chat, or anything else that I can try to answer, and then I'll end with some resources that may be available, particularly to independent inventors and under-resourced inventors. So any questions that may have come through the chat?
Yeah, Steve, this is awesome. We have a lot of questions, so we may end up answering some of them
Okay.
offline. But the National Hardware Show does such a great job, and they bring in people from all over the world, so many different countries. It's such a huge show. And so one of the questions was, if you present your product at the hardware show, and again, without seeing your presentation, you just went there. After you presented, are you able to then hurry up and go and file for your provisional patent? Or is that something like, wow, you're really on the edge?
Right. So the presentation of your product, and presumably you're going to look to patent that product. the presentation would count as and I'm going to jump back a few slides here. The presentation would fall into this orange box here on the right of an example of a public disclosure of your invention, right? So here in the US, think of that, the day that you presented is day one of that 365-day clock that started ticking. So as long as you file your corresponding US application prior to the expiration of that 365-day clock, you will not be barred in the US from being able to get a patent on that. I cannot speak to each country outside the US, their individual laws. Like I said, some countries have no corresponding, 1-year periods. Some have an abbreviated period. Some have conditional periods. So you really do need to preferably work through a patent attorney to understand the nuances of each country's laws, to see what that initial public disclosure might mean for your potential patent in Germany, in Japan, in China, in wherever else you may need to go. But here in the U.S., right, the day you exhibited that product at the NHS, that's the start of that 1-year clock. And again, if you go one day beyond that, you're not going to be able to get protection in the U.S.
Yeah, that's right. And the time goes by fast. We get a lot of potential people who want to display their product, and their first question is, do I need a patent? Do I need to do this? So it's kind of good in a way that they can still display, and we're saying after the show you can still have that time to go ahead and file your provisional or full patent. So that's pretty good.
Mm-hmm.
Okay. Great. And then one other question that that was kind of asked several times. Can you give a quick, I know we don't have too much time, a quick overview of the differences of a design and a utility patent?
Sure. That's a good one, actually. Let me.
And is there a provisional for a design?
So no. So there is no provisional for a design, and I briefly alluded to design patents previously, but just to bring the point home, the utility patent covers what you would traditionally think of as an invention, right? Any new process, any new machine, any new composition of matter, and that you think of any type of drug or pharmaceutical, or any improvements to those things are covered through the utility patent. So a design patent, by contrast, is exclusive to the ornamental look and feel, the ornamental design of some type of functional product. So if you think of a mobile phone, maybe the glass of the phone, there's a particular composition of matter that makes it shatterproof, right? That's the glass of the phone is going to be protected through a utility patent that falls under this composition of matter. Maybe there's a power management system, an algorithm that helps you get better battery life out of the phone, right? That's going to be a process, a new and useful process that can be protected through a utility patent. But the way that the phone is designed, right? Maybe the way that the edges of the phone contour or don't contour, the height, the exact height to width ratio that makes it, easier for people with the variety of hand sizes to use, right? Those types of things, right? The things that are related to the look and feel of a functional product are going to be covered by a design patent. environment. And that can be tremendously important, particularly for physical products, especially if you're going to try to distinguish your product to a consumer who's going to be walking into a hardware store and faced with umpteen different brands of a particular a particular consumer good, and you're counting on visual distinctiveness to be the reason that the consumer chooses your product. That can be tremendously valuable, how something looks and how consumers associate that, with your brand and with the with your particular product. I use the example of the mobile phone, because that's probably one of the more high profile design patent litigations of the last 20 years. Was the litigation between Apple and Samsung that was settled not all that long ago, but the litigation went on for years and years. And uh, at the heart of that litigation, was actually design patents, right? There was accusations that the design of Apple was accusing Samsung basically of saying that the design, the exact contouring of the edges of one of the phones was causing confusion in the eyes of the average consumer. And Apple and Samsung each had an array of design patents, that attempted to show the visual distinctiveness of their particular phone versus their competitors. And that was at the heart of a multi-billion-dollar settlement. Is just how the thing looked, and it was design patents that allowed that ornamental look and feel of a functional product to be protected and to serve as the basis for, again, a multi-billion-dollar settlement. Um, so again, when you think about design patents, you think about, are you going to be competing on the visual distinctiveness of your product? Every year, as automobile manufacturers come up with a um, new design for their latest model car, right? Almost all of those are protected through design patents, from the fender to the slope of the roof line, through how far the door handles stick out or don't stick out or are recessed, right? All of those features, because all of those that are ornamental, at least, and don't relate to the function of the car, are protected through design patents. And happy to talk further about that offline,
Sure.
if folks still have questions.
No, that's
Um,
awesome. So we're going to start wrapping up. Myself, I love the USPTO's website. So much resources on it. Can you just talk a little bit of that? I'm sure we get a lot of people can go there and probably answer many of their questions.
Sure, and I think that's a great place to end it. And like I said, I'll be happy to share these slides with anyone who needs a copy. But you can go to uspto.gov. Um, and there's a wealth of resources there. At the very top of the page, you'll see links towards, if you're new to the patent system or new to the trademark system, just click, I'm new to patents, and it'll present you with all of the resources that we have, in order to walk you through the process of actually filing your application online. How to, all the details on how to upload any forms that you may need. And it's a great one-stop shop, to really take you from just a bunch of drawings that you may have on your desktop or floating around in the lab, and actually converting that into a pending patent application. So again, if there's a number of resources here that I think can be helpful to you, but I'd focus just on USPTO.gov. Look for the patents link on the top of the page, and that'll help walk you through the online filing process.
Awesome.
So
So
I believe we're coming to the end of our time here. So I guess I'll turn it back over to you guys, and I'm happy to stick around if there's any additional Q&A.
yeah. No, awesome. Steve, it's so great. And as usual, as I mentioned, thank you so much for coming in, answering these questions. What I found is that the patent system doesn't seem like so much as a scary thing anymore. It seems like with a good plan, and if you do it smartly, you can really move your product ahead very quickly.
Absolutely, and it's about having someone. And then I guess the last pitch I'll make is it's about having someone to talk to, and that's something that the USPTO can offer as well. That's why we have regional offices across the country to assist inventors, independent inventors. One of the scariest things of the patent system is not necessarily working with the USPTO, but it's the fees that attorneys often charge, right? You can get through the patent system with under $1,000 in fees to the USPTO. But if you work with an attorney, a patent attorney, they're going to charge you upwards of $15,000, $20,000, $25,000 for a single patent application to get it filed and prosecuted and issued. And that's where the USPTO can come in and work with you through our educational programming, through one-on-one consultations, and through programs that can help either offset or defer the cost for qualified inventors to make it easier to get into the system and navigate the system. So we have a wealth of educational resources. We have a wealth of people that are willing to talk with you one-on-one to understand what you have and to understand how to best navigate the IP system. I'll caveat that with saying we're not in a position to provide formal legal advice to anyone, but we are in a position to help you understand how to best navigate the system. So, like I said, at USPTO.gov, and there's a wealth of resources there. You can we have a number of hotlines that you can call, and there's someone on the other end of the phone that's going to be able to help you get to where you need to go.
Excellent. Very good. So again, thank you so much. Everyone who's listening in, Assistant Regional Director, Stephen Koziol, I think I'm pronouncing his name right. Please go on out to uspto.gov.org. Is it .org or .gov, sir?
It is .gov. It is
Okay.
.gov.
USPTO.gov, a wealth of information out there. I love that site. So much information out there. I thank you so much for coming in today and giving us this information on behalf of the National Hardware Show, the UIA. We really appreciate all the time you spent and everything you guys do for us out there.
I appreciate the opportunity, and best of luck to everyone during the rest of the show.
Thank you, sir. Y'all take care.